Hello, this is the first in a series of 3 bite-sized talks about the new Fair Deal guidance which protects public sector employees' pensions rights when their employment transfers to a new company. This new guidance is intended to make it much easier for companies to outsource work from the public sector, reducing the financial impact of providing public sector-like pensions to employees who transfer. This is really good news for all parties involved in outsourcing, but there are a number of things to watch out for when bidding for these contracts. This first talk sets out the basic principles covered in the new guidance. The second talk looks at the potential costs during the contract and in particular the uncertainties around those costs. And the final talk covers what people who already have a contract subject to fair deal should be doing now and what people bidding for contracts now in the future should be looking out for. The Fair Deal guidance says that public sector employees' pensions rights should be protected when their employment transfers to a new company. The original guidance was issued in 1999 and updated in 2004. This said that contractors should set up their own defined benefit pension scheme, providing benefits which must be certified to be broadly comparable by an independent actuary. This has usually been done by the Government Actuaries Department. On smaller contracts, this might mean setting up a pension scheme for a handful of employees, which can be very expensive. Even for bigger contracts, this is likely to add significantly to the costs of the outsourcing, as contribution rates payable to a broadly comparable scheme are generally much higher than those payable in the public sector. The biggest issue for contractors has been the potential for large deficits to build up during the contract. Employees are not particularly keen on this approach either. They would prefer to stay in the public service scheme, which has government backing, rather than move to the contractor's pension scheme. The new guidance, which came out in October, deals with most of these issues by saying that instead employees should stay in the public service scheme and the contractor will sign up to that scheme and pay contributions into it. This does, however, mean that you need to keep track of which employees are eligible for the public service scheme, and this may change during the contract as people change roles. The Fair Deal guidance covers pretty much anyone in a public service pension scheme. Anything under the control of central government and civil service, government departments and agencies, teachers, NHS, but it doesn't cover local authorities who are covered by similar rules known as the Best Value Directive. Having said that, academies are covered even though these may participate in the local government pension scheme. It can be quite tricky to know which rules apply in your situation, so the best thing to do if you are outsourcing from some part of the public sector is to ask which guidance applies in your case and make sure you are clear exactly what your obligations are. New Fair Deal was issued by Treasury on 4th of October 2013 and in theory it came into immediate effect. However, it doesn't apply to contracts which were already under negotiation at that time and, indeed, the guidance from Treasury only sets out very broad principles and we would need to see the detail from each of the relevant schemes before we know how it will apply in any situation. The main schemes such as the Civil Service and NHS have implemented the changes. If your particular scheme hasn't implemented them yet, old Fair Deal will still apply. This creates even more uncertainty if you are bidding for a public service contract at the moment. Not only do you need to work out whether Fair Deal itself applies, you then need to work out whether you're on the new version or still on the old version because the public service scheme hasn't implemented yet or because the contract process started before the new guidance came out. So again, the key thing here is to make sure you understand what it is you are being asked to do and which guidance you are being asked to follow. If you do win a contract under New Fair Deal, then you will need to sign both a commercial agreement with whoever has awarded the contract and also an agreement covering your participation in the relevant public service scheme. That participation agreement will set out all the details about what you have to pay into the scheme, when you have to do it, who is eligible for the scheme, that sort of thing. And that will almost certainly not be up for negotiation. It will be pretty much set in stone and set by the public service scheme. So if there is anything that you don't like in that participation agreement, the only way around that will be by dealing with it in the commercial agreement with the awarding body. So you may put, for example, that you are passing through various costs that you have to pay to the public service scheme on to the awarding body. I hope you have found this presentation useful. For more details about New Fair Deal and how it might affect you, please also watch the next 2 talks in this series. Further information can be found on the outsourcing part of our website under corporate consulting at www.barnett-waddingham.co.uk. You can also contact us on corporate consulting at barnett-waddingham.co.uk or speak to your usual Barnett Waddingham consultant.